Hey there, I'm the MadCatster. I'm glad to see you here. Well, the court has finally ruled on the two pending motions to dismiss in the Iilluminaughtii lawsuit. It's kind of a mess. It's not as clear-cut and as neat as I would have liked to have seen. We're going to talk about what the judge has done. I've got copies of both the decisions because you know me. I've got the deets and all the receipts. And I've also got Cedric being a pain today. So buckle up and let's go. So welcome you guys. We have passed the 50,000 subscriber mark. We're actually almost at 51,000 subscribers. Can you believe it? Thank you guys so much for getting us here. And also, if you're not subscribed, please like and subscribe to the video. We're going to talk about now the two decisions that came down from the judge in the Iilluminaughtii lawsuit. It's really a mess. And I'm going to explain to you my opinion on some of what the judge had to say. It's sort of a good news, bad news kind of scenario. And we're just going to go over, the decisions aren't that long. We're just going to go over both of them. And I'll give you my opinion whether I agree with the judge or not on some of the things he said. So let's get into it.
I'm sure you've all heard of data brokers where companies like take all your personal information and sell it to various people, from spammers to scammers to who knows who. So I searched myself and I was shocked at how many of these data broker companies exist. They get your full name, your address history, your court records, your phone numbers, your family members, and all of this information they make available to whoever pays for it. That's why I've been using Aura, the sponsor of today's video, and I would like to thank Aura so much for sponsoring this video. And I have been trying it out. I had looked, when they approached me, I looked them up, and Forbes magazine gives them an excellent rating, and I've been using it. But I'm really impressed with the wide variety of things that it does, and also they have a really great app that you can use as well. And one of the features of Aura is they will show you which data brokers are selling your information, but you can have them have you opted out of these services, and Aura takes care of all of it. I tried it out. It's really great. It's so easy. It not only reduces the amount of spam that I'll get, but it also protects me from hackers who want this sensitive information. I feel really confident now that Aura is taking care of that for me. If you saw it, but recently AT&T revealed that like the information of over 73 million people they had in their databases got released on the dark web. I mean, how frightening is that? AT&T recommended that people who might have been affected, that they use stronger passwords, they monitor account activity, and that they put either a freeze on their credit reports or fraud alerts with the credit bureaus. Well, what's really awesome, again, is Aura takes care of that for you. You don't have to deal with different apps and different websites in order to accomplish that. If my information had been compromised from AT&T, I know I don't have to worry because Aura is going to keep me safe and take care of it. I value my privacy. I'm sure you do too. I feel secure with Aura, and I want you to feel secure with Aura too. They will give you a 2-week free trial. You can check out Aura and see how great it is. You go to Aura, aura.com/MadCatster. I'm also going to put the link down below in the description that you can click. You should check them out and use that link. It's on the screen here and it's down in the description. And I know that you'll be as happy as I am with Aura.
So the first decision that we have, we'll talk about, concerns Oz Media's motion to dismiss. Now you remember the court has allowed Blair, the Iilluminaughtii, to amend her complaint. So she had a complaint, an amended complaint, and a second amended complaint. Something else comes up in this that really irks me. We'll talk about in a minute. And then Oz basically had to do 2 motions to dismiss because once she got permission to amend her complaint, again, that motion that he first filed was no longer relevant. So let's take a look first at this Oz Media motion to dismiss decision. And it's, Pyramid Entertainment versus Oz Media, and there's the other defendants. And here's the order regarding the motion to dismiss. It says, before the court is a motion filed by defendant Oz seeking dismissal pursuant to the rules of civil procedure and the anti-SLAPP statute of plaintiff's claims against him in the second amended complaint. I have previously allowed 2 amendments of the complaint, following which Oz renewed his motion to dismiss. I have reviewed the renewed motion, the response, the reply, along with the case file and applicable law. So remember, he filed the motion, she filed her response to that, and then he filed a reply, and we've covered all 3 of those different pleading. If you haven't seen my other videos on Illuminaughtii, go please watch them. And here's the applicable standard on a 12b5 motion to dismiss. When considering a motion to dismiss for failure to state a claim, Colorado courts until recently applied the no set of facts standard, dismissing a complaint only if it appeared beyond a doubt that the plaintiff could prove no set of facts that would entitle him or her to relief. In 2016, the Colorado Supreme Court modified that standard by adding the requirement that the complaint state a plausible claim for relief. The court went from this rigid, absolute, you can't prove anything, to you can't prove a plausible claim. So I think it's a little bit more favorable standard for the defendant. Under the Warren standard, the trial court still accepts all allegations in the complaint as true and views them in the light most favorable to the plaintiff. However, facts pleaded as legal conclusions, i.e. boilerplate or conclusory allegations, such as those that merely repeat statutory language, are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. So there has to be some, at least kernel of possibility that the claims are entitled to relief by the court. The courts are fairly liberal in giving leeway to the plaintiffs when considering a motion to dismiss, because they don't want to just dismiss it out of hand if there's any chance, no matter how remote, that maybe some of it is true and can be proven. They want to see the evidence and not just go on the pleadings. So keep in mind now, as we go over these, that just because the judge might say something that's favorable to Blair and unfavorable to Oz or Felix the KitKat does not mean that the court thinks that she's right or that what she's saying is true. The court is merely saying that it's enough, in the court's opinion, to move on toward the discovery phase and eventually to trial, so that the evidence can come into play more to show whether or not she's right and whether or not what she says is true. So just keep that in mind. What we're going to read here in no way means that the judge believes Illuminaughtii over the defendants. That's not what it means, okay? Simply asserting a legal conclusion bereft of any supporting factual allegations does not state a plausible claim for relief. A motion to dismiss for failure to state a claim is a challenge to the facial sufficiency of the complaint. It is directed at the four corners of the complaint, and accordingly, a court generally may consider only those matters stated in the complaint. However, Rule 12b provides that if additional matters outside the complaint are presented, the court has discretion to take those matters into consideration and convert the motion to a motion for summary judgment. So a motion for summary judgment is basically you're saying to the court has all the evidence and proof it needs. There's no need to go any further with this, judge. So basically they're saying, judge, we want the court to rule right now, based on everything that's been presented, that there's no merit to these claims at all. It's not necessary to go to trial. And I told you guys before too that it's very slim odds that the court is going to grant a motion for summary judgment unless it's really, really clear that this is a dog of a case and there's no way that the plaintiff's ever going to prove what they're stating in the complaint. After giving all parties reasonable opportunity to present material that would be relevant on a summary judgment motion, he's saying, I elect not to do so as the motion has not been fully briefed in that posture. So basically the judge is saying he doesn't believe that the motion to dismiss has enough material or enough evidence or enough information in it for him to be able to rule as a motion for summary judgment. And he goes on to say, if matters outside the complaint are submitted to the court but not considered, it is within the court's discretion whether or not to convert the motion to dismiss into one for summary judgment. So he goes on to say that in 2019, Colorado enacted the anti-SLAPP statute to address lawsuits aimed at stifling or punishing the right to free speech, commonly known as strategic lawsuit against public participation, and to provide a procedural mechanism for the early consideration and dismissal of such lawsuits. Colorado's anti-SLAPP statute is directly modeled after California's statute and also codifies pre-existing Colorado case law. The anti-SLAPP statute provides in pertinent part as follows. A cause of action against a person arising from any act of that person in furtherance of the person's right of petition or free speech under the United States Constitution or the state constitution in connection with a public issue is subject to a special motion to dismiss unless the court determines that the plaintiff has established that there is a reasonable likelihood that the plaintiff will prevail on the claim. Colorado follows California's two-step process for considering the special motion to dismiss under the anti-SLAPP statute, and Colorado's courts look to California cases for guidance on how to apply the statute. And we talked about this too, not only in the Iilluminaughtii case, but in the Janet and Lauren the Mortician case against the girlies, that they've also raised anti-SLAPP. And Georgia also is one of the states that looks to California for guidance to see how California interprets the law and to get guidance from that. First, the court determines whether the defendant has made a threshold showing that the conduct underlying the plaintiff's claim falls within the scope of the anti-SLAPP statute. That is, that the claim arises from an act in furtherance of the defendant's right of petition or free speech in connection with a public issue. An act in furtherance of a person's right of petition or free speech in connection with a public issue is defined to include 4 specific types of acts, of which the third is relevant here. Any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest. If the trial court finds that the claim falls within the statute's scope, it then proceeds to the second step. It reviews the pleadings and affidavits and determines whether the plaintiff has established a reasonable likelihood of prevailing on the claim. If the court determines that there is not a reasonable likelihood that the plaintiff will prevail on the claim, the court must grant the special anti-SLAPP motion to dismiss and award the defendant their attorney fees and costs. So now we move on to the first subject, the breach of contract claims that Blair made that Oz has asked the court to dismiss. The first claim for relief for breach of contract alleges that Oz entered into an agreement with Pyramid, the Oz agreement, that required that he not use confidential information and or proprietary data for the benefit of any other person, corporation, or entity other than the employer during the term of employee's employment with employer or any time thereafter. Remember, we talked about she doesn't put a reasonable time limit on this. At any time implies it's open-ended, it's forever. If Oz challenges the validity of this agreement, my guess is that a court would find it's not reasonable and would probably throw it out. But they haven't asked this court to do that, so the court's not going to address whether it's valid or not. They're just going to look at the document and determine whether the conduct Blair complains of is actually a violation. And that he breached the agreement by using confidential or proprietary information to defame or otherwise harm plaintiffs. Example of these breaches are set out in paragraphs 41 and 46 of the complaint. The complaint also references paragraphs 58, 59, 63, and 64, but these paragraphs refer to alleged breaches by other defendants. Oz contends that the breach of contract claim against him should be dismissed pursuant to Rule 12b-5 because it fails to set out with particularity his statements or other conduct that allegedly breached the agreement. The anti-SLAPP statute is not implicated by the claim. Paragraph 41 alleges that in April of 2023, Oz published a series of Twitter, now X, posts naming Blair as the aggressor and falsely claiming that she has a habit of starting fights. These posts also included Pyramid's confidential information. This is what Blair's claiming in the complaint. A link to a Twitter address follows, but clicking on the link does not produce the alleged post. So the court tried to use the link that she provided, and it was broken. Paragraph 46 alleges that in September 2023, Oz released a YouTube video titled Let's Talk, an update on Illuminaughtii drama, which contained accusations in which Oz falsely accused plaintiffs of embezzlement. Nothing in either paragraph sets out the specifics as to how Oz purportedly used confidential or proprietary information to defame or otherwise harm plaintiffs. And so there's a footnote here that the judge put in that I'm going to read because it's important. It says the court notes that in its order of January 15, 2024, authorizing a second amended complaint, the court instructed plaintiff that all statements on which they relied shall be set out verbatim in the complaint. That order was necessary because plaintiffs, in their previous iteration of their complaint, had failed to specifically set out the statements by defendants that they alleged were defamatory, making a substantive review of the complaint impossible. So the court's saying, we don't have enough information. You're not telling us what it is that's defamatory. And this is true of some of the other cases we've talked about, too, where the courts have basically scolded the plaintiffs for not putting out the specifics of the detail that is necessary to show why there's actually a cause of action here. Plaintiffs have again failed to comply. Amen. A link to what purports to be a Twitter thread, even a link that works, is not the same as a verbatim representation of the specific statements to which plaintiffs object. It leaves the parties and the court guessing, and accordingly, it violates the court's very direct and specific order. Finally, identifying the statements in their motion response is inadequate. The statement must be set out in the complaint. So they're saying you can't correct it after you failed to heed the court giving you these instructions more than once by putting out a response to the motion to dismiss and then putting some of it in there and saying, well, here it is. Their point is the complaint has to be complete in itself. Your whole position that you're putting forward of why something has wronged you and you're entitled to relief, the information has to be contained in the complaint so the court knows how to review it and how to analyze it. He goes on to say now, as noted above, under the Warren standard, boilerplate or conclusory allegations are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. No such specific factual allegations support this claim, and accordingly, it is dismissed. So the court has dismissed the breach of contract claim. So, I mean, technically now, really, the whole issue with the confidentiality agreement is kind of moot at this point because it's no longer going to play a role in this lawsuit as far as Oz is concerned, because the court said, you didn't do what I told you to do. It's dismissed. Hallelujah. Thank you, Judge. Absolutely great. Now, we get on to the defamation claims. Oz contends that the remaining claims against him, the third and fourth causes of action for defamation, should be dismissed pursuant to the anti-SLAPP statute, or in the alternative, pursuant to Rule 12b-5 for failure to state a claim, which is what the court looked at when they dismissed the breach of contract claim, was 12b-5 for failure to state a claim. The statements identified in Claim 3 made in a YouTube video by Oz after the case was filed accused Blair of embezzlement. And we talked about that. He did not accuse her of embezzlement. He made it clear he wasn't sure what she said. He's saying she brought that up. Anyways, we've talked enough about that. The statements identified in Claim 4 made by Oz in the same YouTube video accuse her of having placed him in a dependent, arguably coercive financial relationship with her. And then he goes on to analyze whether the anti-SLAPP statute applies here. And this is what he has to say, and I don't agree with him. The judge says, I find the anti-SLAPP statute does not apply because Oz cannot satisfy the threshold part of the analysis. While the parties agree that Oz's statements were made in a public forum, they were not made in connection with an issue of public interest. Now, we talked about public interest before. Oz's attorneys cited some case law. I disagree with the judge here. I think it is a matter of public interest, and I'll talk a little bit more about it, but let's just continue and finish reading this, and then I'll talk about it. Neither of the statements identified in Claims 3 or 4 were made in connection with an issue of public interest. While they were made in the public forum of the internet, and while Blair may or may not be a public figure, they arise out of a private dispute between Oz and Blair, and they solely address that private dispute as opposed to larger, more public issues. Now, and they cite this damn veterinary case that Blair cited to, which I think totally irrelevant and is not on point here. Here's the thing. Yes, correct. It was a private dispute. However, it became a public dispute. Both parties made it a public dispute when they went into excruciating detail on both sides, whether what they allege is true or not, about these issues and put it out there in a public forum. So, yes, it may be a private dispute, but it isn't anymore. It's now in the public. And the public is obviously very interested. I don't think the case law supports that conclusion, if that's what the judge is trying to say here. And I think for the reason I just stated that, yes, it may have originated as a private dispute. It's no longer a private dispute. Courts have kind of broadened that beyond. It's not just about like things going on in the community, you know, issues of public interest. It's stuff that the public's interested in. And clearly the public's interested because it's garnered a lot of attention from the public. He goes on to say the statements by Oz express a personal grievance arising out of their personal relationship. They lack any nexus with any issue of public interest, and they do not contribute to any broader public discussion of any social or political issue of public interest. Thus, the anti-SLAPP statute does not apply. I don't agree with you, Judge. Again, that doesn't mean the judge is siding with Blair or thinks that she's right. He doesn't think that he has grounds to dismiss this count. It needs to proceed on the trial track. So he's not going to just toss it out at this stage. And so he goes on to analyze this. Because the anti-SLAPP statute does not apply, the court must assess whether the claims against Oz satisfy the Warren standard. So whether it can be dismissed for failure to state a claim instead of for anti-SLAPP. The traditional elements of defamation are a defamatory statement concerning another published to a third party with fault amounting to at least negligence on the part of the publisher, and either actionability of the statement irrespective of special damages or the existence of special damages to the plaintiff caused by the publication. Oz contends that plaintiffs must meet the enhanced actual malice standard set out in New York Times v. Sullivan because the challenge statements relate to a public figure. That standard also applies if the statements relate to a matter of public concern, but as discussed above, they do not, in his opinion. However, I will not apply the actual malice standard in this posture because the evidence as to whether Blair is a public figure consists for the most part of matters outside the four corners of the complaint. I'm not quite understanding why he's saying this. So basically he's saying, well, it wasn't argued in the complaint that she's a public figure. That's something the court has to decide based on an analysis of the whole situation. And he's claiming, oh, it's not in the four corners of the complaint, so we can't decide whether she's a public figure. I don't know. I think it's absurd. And I decline to convert the motion into a motion for summary judgment. Thus, for the purpose of this motion, I will apply the traditional elements of a defamation claim as set out above. Oz's challenge focuses first on the first element of the claims, namely whether his statements were defamatory. To determine whether a statement is defamatory, the courts employ a two-part test. A court must determine whether the statement consists or implies a verifiable fact about the plaintiff. And second, whether the statement reasonably is susceptible to being understood as an assertion of actual fact. Claims 3 and 4 meet this standard. The statements made in both claims contain or imply verifiable, I guess he's talking about when the evidence is presented and through discovery, whether or not it can be proven that she embezzled. So apparently there's going to be a lot of financial documents coming from Blair's side in discovery. So I hope she's prepared to, shine a light on her financial dealings. Claims 3 and 4 meet this standard. The statements made in both claims contain or imply verifiable facts about Blair that she committed the crime of embezzlement and that she placed Oz in a dependent, coercive financial relationship. Oz contends next that plaintiffs have failed to sufficiently prove special damages in connection with Claim 4, defamation per quad, contending that the drop in revenue alleged in that claim occurred before rather than after the contested statement. That is, in fact, what the complaint alleges. I do not consider the additional materials that Oz submits in connection with this argument. Claim 4 is based on a September 16, 2023 video, the Let's Talk video, but it then alleges that Oz's statement caused special damages as evidenced by the fact that plaintiff's revenue from videos dropped by more than 95% in the period September 16, 2022 to October 1st, 2022, from $47,665 down to $2,312 during the same period a year later. Thus, as alleged, that drop in revenue took place in the year before rather than after the Let's Talk video. As a result, Claim 4 fails to plausibly allege the required element of special damages. Accordingly, I find that Claim 3 satisfies the Warren standard, but Claim 4 does not. So, basically, he's dismissing the claim for special damage. She's comparing a whole year's worth of revenue, most of that occurring before Oz's video came out. That doesn't show me that your revenue dropped precipitously right after he posted his video. You're saying that it dropped over a 1-year period. I note finally that the complaint is defectively pleaded in that it fails to set out each alleged defamatory statement in the form of a separate claim. So the judge wanted to see count 1 defamation and then a statement, count 2 defamation and then a statement, rather than lumping them all together. Only those that have been separately set out in Claims 3 and 4 will be considered to be claims for defamation. Those that have not been set out in that way will not be treated as such. So he's not going to consider any other allegedly defamatory statements other than the embezzlement allegation and the one about the coercive financial relationship. I mean, that's a partial win for Oz because that narrows it down. The 9th claim for relief. Oz objects to plaintiff's 9th claim for relief for computer fraud. Okay, now this is sticky. This is where I get really annoyed with the judge, okay? Remember we talked about how the judge had ordered her to file a second amended complaint, basically to give the specifics that the court asked for and to spell it out so the court could clearly see what she was alleging was defamatory. And she didn't do that. And the court has even said that she didn't do that. But we talked about how Blair's team took the opportunity in filing this second amended complaint to add in a claim for computer fraud. And I had said that in my opinion, when I read the court's order, it is clear to me that what the court's inferring is you need to file a second amended complaint because you need to give us more detailed information about what you're alleging is defamatory here. And Blair's team argued that we're throwing this in because the judge just said file a second amended complaint and didn't say we couldn't. And to me, that seemed like a ridiculous argument. But this is now what the court has to say, and I'm really disgusted with the judge. So it says, Oz objects to plaintiff's 9th claim for relief for computer fraud on the ground that amendment to include this claim was not approved by the court. Defendant responds that the court's order of January 15, 2024 authorized the second amended complaint without restricting the claims that could be alleged in it. I'm not sure, but it appears to me that the judge, this is a typo, and that it should say plaintiff responds that the court's order authorized the second amended complaint without restricting the claims that could be alleged in it, because that's what Blair's team argued. So I think that's just a typo. The judge says, I agree the order was not clear as to the scope of the second amended complaint that it authorized. While the order was clearly issued in response to defects in the defamation claims, it did not expressly limit amendments to those claims. Before I read the rest of this, the other thing that we have to remember is not only did she not comply with the court's order in the second amended complaint to give the detail the court wanted, but she filed it a week late and didn't get the court's permission. And the judge had said that it had to be filed on a certain date or he would grant the motion to dismiss. And he didn't do that. And she didn't ask permission to file it late. She just filed it late. So that annoys me too, that he's giving her leeway. So this is the rest of what he says. I will resolve the issue with an eye to practicalities. No objection has been raised to the 9th claim for relief other than the authorization issue. Were the court to require a motion to amend in order to address this new claim, it would only delay the long-delayed case further. Now, why would the court allow them to file a motion to amend the complaint again? I thought the court had said the second amended complaint was going to be it. So you're saying that because maybe the order wasn't specifically clear enough, even though the court says it was in response to the defects in the claims for defamation, the court's now going to reward her for being late in filing her response and for throwing this extra item in for which she's not gotten permission from the court, and yet the judge is just going to let it ride? I think that's preposterous. So this is basically now a third amended complaint. And he's given her way, way, way too much leeway. And if I didn't know better, I would think the judge was partial to Blair's side. So he's saying that he's going to treat the order as authorizing all remaining amendments to the complaint, and he's going to approve the inclusion of the 9th claim for relief in the second amended complaint. But it will be my expectation that the complaint is now in its final form. I thought it was in its final form the last time. Now it's in its final form. So even though he told her that she needed to amend it to clarify, because she's thrown this in, he's going to say, well, I didn't mean that was the final one. Now it's the final one. Conclusion, for the reasons set forth above, Oz's motion to dismiss is granted in part. Dismissal of the first and fourth claims of relief against defendant, Oz, is granted. Dismissal of the third and 9th claim for relief is denied. So basically what we're left with is the third and 9th claims for relief, the defamation in terms of the allegation of embezzlement and of the coercive financial relationship, and this new 9th claim for relief for computer fraud. Now, even though I'm mad at the judge for giving her so much leeway, it does not mean that he's saying she's correct in what she's alleging. Okay? That's got to be determined at trial by presenting evidence. She has to support all of this with evidence. And Oz will have his chance to present evidence to refute what she's claiming. So that's what the court has ruled on Oz's motion to dismiss. It's a partial win for Oz. It's a partial win in so far as it didn't get dismissed for Blair. It's not an endorsement of the validity of her claim. The court doesn't feel comfortable dismissing the rest of it at this stage, which is unfortunate because I think this is a waste of time and money. But now let's take a look at Felix the KitKats. Now, I thought of all of the three defendants, Felix the KitKat had a slam dunk in terms of getting his dismissed. Well, the judge has disappointed me there too, and we're going to talk now about what he said. And this one's pretty short, but I was scratching my head after I read it because I was like, what? So here we have Plaintiff Pyramid Entertainment versus the defendants. Order regarding defendant Felix the KitKat's motion to dismiss claim for breach of contract. Before the court is the motion filed by defendant Felix seeking dismissal pursuant to Rule 12b-5 of plaintiff's breach of contract claims against him in the second amended complaint for failure to state a claim. I previously allowed amendment of the complaint, following which Felix renewed his motion to dismiss. I reviewed the renewed motion, the response, and the reply, along with the case file and applicable law. I'm not going to go over the legal standard again because we went over it in just a minute ago in Oz. What constitutes failure to state a claim for relief? So we don't need to go through that again. It says, under the Warren standard, the trial court still accepts all allegations of the claim as true and views them in the light most favorable to the plaintiff. However, facts pleaded as legal conclusions are no longer entitled to presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. And so here he is doing an analysis. He says, viewing the amended complaint in the light most favorable to the plaintiff, the court accepts that the portion of the YouTube video referenced in paragraph 63-64 of the complaint is the same as the one displayed via screenshots in paragraphs 116 to 20, which has the same link. It shows Blair instructing her employee, Felix, to help me find Click, a former employee now competing YouTuber. Competing? They don't do the judge. I don't know if you watch YouTube, but they don't cover the same kind of stuff, so they're not really competitors. That's like saying that, you know, the car dealership is in competition with the computer sales shop, you know? She wanted him to find Click saying the R slur, and it's here, but I'm not going to read it, in Sad Milk's raw audio, and offering to pay him $200 to find it. Sad Milk's YouTube channel created and managed by Plaintiff Pyramid, and that's what Blair said in the complaint. Again, viewing the amended complaint in the light most favorable to plaintiff, these allegations arguably state plausible claims for relief of both the NDA and the Felix agreement. They arguably state a plausible claim for breach of the NDA in that they plausibly allege that Felix, without permission, shared with a third party pyramid information about company operations, as well as information regarding an individual's involvement in pyramid operation. They likewise arguably state a plausible claim for breach of the Felix agreement. They allege that Felix, without permission, shared with a third party confidential information for the benefit of a third party. Now, here we go. Okay, first of all, so it sounds like the judge is accepting Blair's assertion that Sad Milk was managed by Pyramid. Okay, I'm going to talk about in a second why all of this is nonsense, but let's just examine that. So Click wouldn't be a third party then, because Click was part of that whole Sad Milk operation. So it would be from employee to employee, wouldn't it? If you're trying to say that Sad Milk is the entity here, then sharing Sad Milk information with the Click would be basically an internal share, wouldn't it? So he's not a third party. He was part of the operation. So first of all, that right there, that doesn't make any sense, what the judge is saying here. But it gets better, okay? He likewise arguably state a plausible claim for breach of the Felix agreement. They allege that Felix, without permission, shared with a third party confidential information for the benefit of a third party. Okay, first of all, how does it benefit Click? That Felix is telling Click that Blair asked him to do this. I don't see how that benefits Click. It's basically saying, look, dude, she was trying to screw you over. I don't see how that benefits him in any way other than just to make him aware of it. But again, we're talking about in the context of Sad Milk, then they are all part of that group. So how is this a third party situation? Okay, but here's the part that really bothered me the most. The confidential information discloses not, as Felix's counsel suggests, that Blair uses the arsenal in private. That would be a private matter rather than company business. Rather, the potentially actionable conduct by Felix was his disclosure of internal company messages and operations, namely Blair instructing her employee to find potentially damaging information about a competing YouTuber. Click. Again, Click was part of Sad Milk. What's he talking about? While disclosing such tawdry information to a competitor may not be a violation of the Uniform Trade Secrets Act, it could plausibly be a violation of the agreement that Felix signed as it disclosed to a competitor. He's not a competitor, Judge. You're assuming that all YouTubers are in competition with each other. That's just ridiculous. That's like saying the New York Times is in competition with People magazine. They're not in competition. They're not even in the same ballpark. Click does like silly Reddit stuff. Blair exposes MLMs, or used to. They're not in competition, Judge. You know? Educate yourself on what these people do. It could plausibly be a violation of the agreement that Felix signed as it disclosed to a competitor the internal operations of a company whose business arguably involved trolling for clicks and bringing down its competitors. Now, he's confusing Sad Milk with Pyramid here. Sad Milk, that's not what Sad Milk did. That's what Blair does in her Iilluminaughtii channel. So the judge is like conflating a whole bunch of stuff here. As the complaint alleges, large amounts of money were at stake. Please. Large amounts of money. How are they at stake? How is Felix telling Click that Blair was trying to screw him over involving large amounts of money? But here, aside from my issue with Judge not understanding the business that these people are in and their differences in what they do, I'm annoyed with the judge because there's one glaring fact here. Fact. That should automatically have had him dismiss this. I told you guys in my video, one of my videos, that if you look at the messages that are at issue, first of all, they were not company messages. They were private discourse between Blair and Felix. It had nothing to do with the company. She was paying him out of pocket $200, not as an employee, but as someone who was not an employee, and trying to get him to do some dirty work for her so that he could earn a little bit of extra cash. The glaring problem with this is the messages were created, not only are they not company messages, a year before he signed his non-disclosure agreement and went to work for Blair in her pyramid company. So he was not an employee, Judge, number one. Number two, the messages weren't company messages. They were a year before he was an employee, and they were private messages between the two of them. So they're not covered by any of this. The NDA has nothing to do with those messages. And so it should have been crystal clear to the judge that automatically that made these claims bogus, and he should have dismissed Felix out of this lawsuit. I thought it was black and white, cut and dry. Apparently the judge, in my opinion, is not doing his due diligence in understanding what's going on with these people and what they do and how they interact with one another. I rolled my eyes when I read this because I was like, oh my God, you're kidding me. So poor Felix has to continue to fight this when he shouldn't have to fight it. If I was his team, I would file a motion for reconsideration. And I would make it very clear to the judge and provide the NDA and the messages and say, Judge, it's right in front of you. The messages were not done while he was an employee. Therefore, they're not covered by the NDA. So dismiss it already. And so I hope they file a motion for reconsideration. If they're listening, file a motion for reconsideration, guys. Come on, this is ridiculous that this is going to continue. It says, for the reasons set forth above, I find that Claim 1 and Claim 2 in Plaintiff's Second Amendment complaint each state a plausible claim for breach of contract against Felix under the Warren standard, and accordingly the motion to dismiss is denied. Well, I think that's a travesty for the reasons I just stated. Felix shouldn't be in this. And Blair, shame on you. Shame on you. Shame on you for terrorizing and going after this kid for something that's a non-issue. You know, I'm sorry if you don't like the fact that your dirty tricks got exposed, but he didn't breach his NDA. Not only that, but Felix should file a suit against her to invalidate that NDA. They all should. Those NDAs aren't worth the paper they're written on. They're too broad. They were written basically for high-tech companies. So, she cut and pasted probably from the internet because she didn't want to pay somebody to draft her an appropriate confidentiality agreement and an appropriate NDA. I think all three of them are invalid. I don't understand why it wasn't made crystal clear to the judge that, look, date here, date here. They don't correlate, Judge. This thing she's complaining about happened before he signed this and before he was her employee. Tell me what you think down below. I'd be interested to hear it. Are you as disappointed as I am? So we're going to march on. At least we got part of it dismissed. And as far as Wonder goes, I know we haven't really talked about it, but Wonder was never served. So I'm expecting, I don't know why it still hasn't happened, that the court's going to dismiss Wonder from the complaint because he was never served. I still think ultimately Oz is going to prevail. It just seems like a waste of time and money on everyone's part. And in fact, a lot of you know and have pointed out to me, and I did watch it. Oz put out a video a few days ago where at the end of it, he made an open invitation to Blair and her team for them to just settle this whole matter and just move on with their lives. It's my understanding that Blair's team has responded to him, saying that they will consider it. We'll have to see how that develops. Go watch Oz's video. He's also been live streaming like every night. They're raising more money for the legal defense. Let me know what you think down below. Thank you for joining me. I'm sorry, I know my voice is still hoarse. I've been out of the hospital 2 weeks now and I still can't talk, but life goes on. I have to keep going. Thank you so much, you guys, for your support. Thank you for getting me to 50,000. I want to say thank you so much, as always, to our Patreon patrons. You guys are amazing. We've added a couple of new patrons. The list keeps growing. And as I've stated a million times, the Patreon and channel member money is all going towards the cat's veterinary bills. It doesn't cover them, but it helps. Okay, so thank you for your support. It's so important to me, the channel members and the Patreon patrons. And thank you to the new people who have joined us. If you're interested, the link's down below. I also have some people to thank for Amazon, because we did get some stuff, and I do have some people to thank for buying me coffee. So first, I'd like to just say that a couple of packages came from Amazon with no slips. Whether that's intentional on the part of the sender, I don't know. So if I don't mention you, please get in touch with me through my email, realmadcatster@gmail.com. Let me know. I do want to thank Anne for sending us a nice kitty window seat. Those are awesome. The cats love those. And actually, there's 2 of them that need to be replaced, so this is perfect. And I would like to thank Mindy F, who sent us a bunch of stuff. Mindy sent us some Purina Friskies pate cat food, some of the catnip mice, one of the nice cat beds, and also toy ball with a jingle inside of it, which the cats really like. So thank you, Mindy F, for that stuff. So if I did not thank you and you sent something, please let me know. It's not on purpose. It just, I don't have a sub to tell me who sent this stuff. So anyways, I'm going to be checking in on a couple of the lawsuits, but there's also a couple of new ones that have come up that I might cover, because I think there's some interesting angles to talk about. But in the interim, like and subscribe. Take care of yourself, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.